I never thought filing for a simple building permit would land me in federal court. But that's exactly what happened when I decided to build a wheelchair ramp for my daughter at our home in Scottsdale, Arizona. My name is Xavier Grayson, and I've been living in the Sunset Ridge Estates community for 8 years. My wife, Grace Fletcher, and I moved here when we were newlyweds, attracted by the clean streets, good schools, and friendly neighborhood vibe. We had our daughter Emma 3 years later, and life seemed perfect. Then, 2 years ago, everything changed when Emma was diagnosed with a progressive neuromuscular disorder. At first, she could still walk with assistance, but by last summer she needed a wheelchair full-time. Our house had 3 steps leading up to the front entrance, which meant I had to carry Emma in and out every single time. She was growing, getting heavier, and I knew this wasn't sustainable. Plus, Emma deserved independence. She deserved to come and go from her own home without relying on someone to physically lift her. In March, I contacted a contractor and got quotes for installing a wheelchair ramp. The design was straightforward, nothing fancy, just a regulation-compliant ramp that would give Emma access to our front door. I submitted the plans to the city, paid the permit fees, and got approval within 2 weeks. I thought that was it. I scheduled the construction to begin in April. Then I got the letter. It arrived on a Tuesday afternoon, stuffed in my mailbox alongside the usual junk mail and bills. The return address read, Sunset Ridge Estates HOA Board, and I figured it was probably another reminder about the annual meeting or something about the community pool schedule. I opened it while standing at my kitchen counter, Emma doing homework at the table behind me. "Dear Mr. Grayson," it began in that formal, cold tone that immediately put me on edge. "It has come to the attention of the Sunset Ridge Estates Homeowners Association Board that you have filed for a building permit to construct a wheelchair ramp at your property, located at 2847 Desert Bloom Lane. According to Section 7.3 of the HOA Covenants, Conditions, and Restrictions, all exterior modifications must receive written approval from the Architectural Review Committee before any construction begins. As you have not submitted the required application or received such approval, we hereby demand that you cancel your scheduled construction immediately. Failure to comply will result in legal action. Sincerely, Patricia Kendall, HOA Board President." I read it twice, then a third time, feeling my blood pressure rise with each pass. Patricia Kendall, of course it was her. Patricia had been the HOA president for 6 years, and in that time, she'd built a reputation as someone who treated the community rules like they were the 10 Commandments carved in stone. She'd once fined a neighbor $300 because his mailbox was painted the wrong shade of brown. Another family got threatened with a lien because their Halloween decorations stayed up until November 2nd. But this was different. This wasn't about holiday decorations or mailbox colors. This was about my daughter's ability to access her own home. I called the HOA office immediately. A woman named Brenda answered, her voice chipper and unhelpful. "Sunset Ridge HOA, how can I help you? This is Xavier Grayson. I just received a letter from Patricia Kendall about my wheelchair ramp, and I need to speak with her right away." "Oh, Mr. Grayson, yes. Patricia mentioned you might call. She's not available right now, but I can take a message." "Not available? This is urgent. I have a disabled daughter who needs this ramp." "I understand, sir, but Patricia is very busy." If you'd like to submit an application to the Architectural Review Committee, you can find the forms on our website. The review process typically takes 4 to 6 weeks. 4 to 6 weeks. I already have city approval. Construction is supposed to start next week. Well, city approval is separate from HOA approval, Mr. Grayson. The CC and Articus are very clear about this. All exterior modifications require HOA approval first. I wanted to reach through the phone and shake some sense into her, but I kept my voice level. Fine, send me the application. But I need to speak with Patricia as soon as possible. I'll let her know you called. She hung up, and I stood there staring at my phone, fury radiating through every cell in my body. Grace came into the kitchen, took one look at my face, and asked what was wrong. I showed her the letter. "They can't do this," she said immediately. "Emma needs that ramp. This is discrimination." "That's exactly what it is," I agreed, "but apparently they don't see it that way." I spent the rest of that evening researching HOA law and disability rights. What I found both encouraged and terrified me. The Fair Housing Act, a federal law, required HOAs to make reasonable accommodations for people with disabilities. A wheelchair ramp for a disabled child seemed like the textbook definition of reasonable accommodation. But I also found horror stories about HOAs dragging disabled homeowners through expensive legal battles, burying them in legal fees until they gave up. I wasn't going to give up, not when it came to Emma. The next day, I filled out the HOA's architectural review application. It was 6 pages long, asking for detailed plans, material specifications, color samples, and a non-refundable $200 application fee. I provided everything they asked for and hand-delivered it to the HOA office that afternoon. Brenda accepted it with a plastic smile. "Thank you, Mr. Grayson. We'll review this at the next committee meeting." "When is that?" 3 weeks from now." 3 weeks. Can't you schedule something sooner? This is time sensitive. The committee meets on the 3rd Thursday of every month. That's the schedule. I left the office feeling like I just tried to negotiate with a brick wall. But I remained hopeful that once the committee actually reviewed the application and understood the situation, they'd approve it quickly. I was wrong. 5 weeks later, after I'd called the office 4 times asking for updates and getting nothing but vague promises that they were still reviewing, I received another letter. This one was even shorter than the first. "Dear Mr. Grayson, your application to construct a wheelchair ramp has been denied. The proposed structure does not comply with the community's aesthetic standards as outlined in the CC and Articus. Wheelchair ramps are not permitted on front-facing facades. Please consider alternative accessibility solutions that do not impact the community's visual appeal. Sincerely, Patricia Kendall, HOA Board President." I crumpled the letter in my fist. Visual appeal. My daughter's ability to enter her own home was being denied because of visual appeal. Grace was at work when I got the letter, so I called her immediately. Her response was just as furious as mine. "They're saying Emma's disability makes the neighborhood ugly. That's what they're really saying." "I know," I said, my jaw tight. "We need a lawyer." That evening, after Emma was in bed, Grace and I sat at our dining room table with our laptop, searching for attorneys who specialized in disability discrimination and HOA law. We found a firm in Phoenix called Steinberg and Associates that had successfully handled several Fair Housing Act cases. I called first thing the next morning and got an appointment for the following week. The attorney who took our case was a woman in her 40s named Rebecca Steinberg. She had sharp eyes behind designer glasses and an air of competence that immediately put me at ease. I explained the situation while Grace sat beside me, occasionally adding details I forgot. Rebecca listened carefully, taking notes on a legal pad. When I finished, she leaned back in her chair and nodded. "This is a clear violation of the Fair Housing Act. The FHA requires HOAs to make reasonable accommodations for disabled residents. A wheelchair ramp is about as reasonable as it gets." "So we can fight this?" I asked. Absolutely. But I want to be upfront with you about what this might involve. We'll start by sending a demand letter to the HOA, citing the Fair Housing Act and demanding they approve your ramp. Most HOAs back down at that point because they don't want the legal exposure. But if they don't, we'll need to file a lawsuit in federal court. Federal court, Grace said, her eyes widening. The Fair Housing Act is federal law, so yes. The good news is that if we win, which I'm confident we will, the HOA will be responsible for our attorney fees. The law specifically allows for that to encourage people to enforce their rights. I felt a weight lift off my shoulders. How long will this take? If they settle after the demand letter, we could have approval within a few weeks. If we have to file suit, it could take several months, maybe longer if they really want to fight. Whatever it takes, I said. Emma can't wait forever, but she deserves better than this. Rebecca drafted a detailed demand letter, citing specific provisions of the Fair Housing Act and Department of Housing and Urban Development regulations. She sent it via certified mail to the HOA board, with copies to Patricia Kendall personally and the HOA's registered agent. The letter gave them 10 days to respond and approve the ramp. The 10 days came and went. No response. Rebecca called their office. Brenda claimed she'd pass the message along. Another week passed. Still nothing. They're stonewalling, Rebecca said during a phone call. This is actually good for us. It shows bad faith on their part. We're filing the lawsuit. In late June, we filed a federal lawsuit in the United States District Court for the District of Arizona. The complaint alleged that the Sunset Ridge Estates HOA had violated the Fair Housing Act by refusing to make a reasonable accommodation for Emma's disability. We asked the court to order the HOA to approve the ramp and to award attorney fees and damages. The local news picked up the story. A reporter from the Phoenix television station came to our house and interviewed us on our front steps, those same 3 steps that Emma couldn't navigate on her own. Emma sat in her wheelchair beside me, and when the reporter asked her how she felt about the situation, she said something that made me tear up. "I just want to go in and out of my house like other kids," she said simply. The story aired that evening and my phone started ringing. Neighbors I barely knew called to express their support. Some were furious with the HOA. Others shared their own stories of ridiculous HOA overreach. A few told me they'd wanted to quit the board years ago, but Patricia ran it like her personal fiefdom and made it impossible for anyone to challenge her. The HOA finally responded to our lawsuit in mid-July, but their response made everything worse. Instead of backing down, they doubled down. Their answer to our complaint didn't just deny our allegations, but filed a counterclaim against us, seeking an injunction to prevent us from building the ramp and demanding we pay the HOA's attorney fees for what they called our frivolous lawsuit. Can they do that? I asked Rebecca when she called to tell me. They can file it, but it's not going anywhere. If anything, this counterclaim is going to make the judge angry. It's clearly retaliatory, and courts don't like that, especially in fair housing cases. Our first court hearing was scheduled for August 15th. It was technically a status conference, where both sides would update the judge on the case and discuss scheduling. Rebecca warned me that these initial hearings were usually pretty dry, just procedural stuff. But she suggested Grace and I attend anyway, so the judge could see the real people behind the case. The courthouse was downtown Phoenix, a modern building with high security. Grace and I went through metal detectors and found the courtroom on the 4th floor. Rebecca met us outside, looking professional in a navy suit. "The judge assigned to our case is Judge Michael Warren," she said. "He's been on the bench for 12 years, generally fair, and he has a reputation for not tolerating nonsense. That's good for us." The HOA's attorney was a man in his 60s named Douglas Chambers. He wore an expensive suit and had the kind of slicked-back gray hair that suggested he spent more time in court than out of it. He ignored us completely while we waited for the hearing to begin. Judge Warren entered promptly at 10. He was African-American, probably in his late 50s, with glasses and an air of no-nonsense authority. Everyone stood until he took his seat. "All right," Judge Warren said, looking at the papers in front of him. "This is case number CV 260847, Grayson versus Sunset Ridge Estates Homeowners Association. Counsel, please state your appearances." Rebecca stood. "Rebecca Steinberg for the plaintiffs, Your Honor." Chambers stood next. "Douglas Chambers for the defendant, HOA, Your Honor." "Very well. I've reviewed the pleadings in this case, and I have to say, I'm troubled by what I'm seeing here." Judge Warren looked directly at Chambers. "Mr. Chambers, can you explain to me why your client believes it's appropriate to deny a wheelchair ramp for a disabled child?" Chambers cleared his throat. "Your Honor, this isn't about denying accessibility. The HOA simply requires that all exterior modifications comply with the community's architectural standards. The plaintiff didn't follow the proper procedures, and the proposed ramp doesn't meet the aesthetic requirements outlined in the CC and Articles." "Aesthetic requirements," Judge Warren repeated, his tone flat. "For a wheelchair ramp, for a child who cannot otherwise access her home. The CC and Articles apply to all residents equally, Your Honor. The HOA cannot make exceptions, even for sympathetic situations, without undermining the entire covenant structure." I watched Judge Warren's expression darken. "Counsel, are you familiar with the Fair Housing Act?" "Of course, Your Honor." "Then you know that the Act requires HOAs to make reasonable accommodations for disabled residents, and that aesthetic concerns are generally not sufficient grounds to deny such accommodations." "Your Honor, the HOA disputes that this is a reasonable accommodation. There are alternative accessibility options that don't require a front-facing ramp." "Such as?" Chambers hesitated. "The plaintiff could install a ramp at the rear of the property or modify a garage entrance." Rebecca stood. "Your Honor, if I may respond, please. The Graysons' garage is not attached to their house. To access it, they would have to go outside, which defeats the entire purpose of accessibility. The rear of their property has a 6-foot slope due to the lot grading, which would require a ramp approximately 70 feet long to meet ADA grade requirements. That's not only cost prohibitive, it's physically impossible given their lot size. The front entrance is the only practical option." Judge Warren nodded. "That's what I thought. Mr. Chambers, I'm going to be very clear with you and your client. The Fair Housing Act is federal law and it supersedes your HOA's covenants. This is not a close case. Your client is on extremely thin legal ice here. Your Honor, with respect, the HOA believes its position is sound and intends to defend this case vigorously." The judge removed his glasses and pinched the bridge of his nose. "Mr. Chambers, I'm trying to save your client from a very expensive mistake. If you proceed with this case and lose, which I believe you will, your client will be liable for the plaintiff's attorney fees. Moreover, if I determine that your client's actions were willful or in bad faith, I can impose additional penalties. We understand the risks, Your Honor." "I'm not sure you do, but very well. Miss Steinberg, do the plaintiffs wish to proceed with their claims?" Rebecca stood again. "Yes, Your Honor. We'd also like to request expedited discovery and an early trial date. The Graysons' daughter needs this ramp now, not in a year." "Agreed. I'm setting a trial date for October 20th. That gives both sides 2 months for discovery. I'm also going to schedule a settlement conference for September 15th. I strongly encourage both parties to use that time to reach a resolution." Judge Warren looked meaningfully at Chambers. "Some cases should never go to trial, counsel. This is one of them." As we left the courtroom, I felt cautiously optimistic. The judge clearly saw through the HOA's arguments, but Rebecca tempered my expectations. "Warren's right, this case should settle," she said. But HOAs can be incredibly stubborn, especially when they have board members who see themselves as defending some kind of principle. We need to be prepared for them to take this all the way. Over the next month, we went through discovery. Rebecca sent the HOA written questions, requests for documents, and scheduled depositions of the board members. The HOA did the same to us, though their questions felt more like harassment than legitimate legal inquiry. They asked about Emma's medical condition, her prognosis, whether we'd considered moving to a different house, and whether we'd looked into less invasive accessibility solutions. The depositions were scheduled for early September. I was deposed first, sitting in a small conference room at Chambers' law office with a court reporter typing every word. Chambers asked me the same questions over and over, trying to trip me up or get me to say something he could use against us. The whole experience was exhausting and infuriating. But the real fireworks happened during Patricia Kendall's deposition. Rebecca scheduled it for September 8th at her office. I attended, sitting quietly in the corner while Rebecca questioned Patricia at the conference table. Patricia showed up wearing a St. John knit suit and pearls, looking like she was on her way to a country club luncheon rather than a legal proceeding. Her blonde hair was sprayed into submission, and she had that pinched expression some women get when they spend too much time disapproving of everyone around them. Rebecca started with basic background questions about Patricia's role on the HOA board, how long she'd served, and what her responsibilities were. Patricia answered in clipped, formal tones, clearly annoyed at having to be there. Then Rebecca shifted to our case. "Miss Kendall, when did you first learn that Mr. Grayson planned to install a wheelchair ramp?" "I believe it was in March, when the property management company informed me he'd filed for a city permit." "And what was your reaction?" "I was concerned that he hadn't followed proper HOA procedures." "Did you consider the fact that the ramp was for his disabled daughter?" "Of course, but the rules apply to everyone equally." "Did you contact Mr. Grayson to discuss the situation?" "I sent him a letter explaining the HOA's requirements, but you didn't call him or meet with him in person." "No, the letter was sufficient." Rebecca pulled out a copy of the letter and showed it to Patricia. "This letter demands that Mr. Grayson cancel his construction plans and threatens legal action if he doesn't comply. Is that correct?" "Yes." "Did you consider that threatening a disabled child's family might not be the most appropriate approach?" Chambers objected, but Rebecca had made her point. She moved on. "When Mr. Grayson submitted his architectural review application, who reviewed it?" "The Architectural Review Committee." "And who sits on that committee?" "Myself, Brenda Johnson, and Harold Winters." "So you personally reviewed and denied the application. The committee made the decision. But you're the president of that committee, correct?" "Yes." "And you're also the president of the HOA board?" "Yes." "So essentially, you made the decision." Patricia's lips thinned. "The committee voted. It wasn't just my decision." Rebecca showed her another document. "This is the committee's meeting minutes from May 20th, when they reviewed Mr. Grayson's application. According to these minutes, the meeting lasted 7 minutes. Is that correct?" "If that's what the minutes say." 7 minutes to review a wheelchair ramp application for a disabled child. Did you discuss the Fair Housing Act during that meeting?" "I don't recall." Did anyone on the committee suggest that denying the application might be illegal? No. Did you consult with an attorney before denying the application? Patricia hesitated. No. Why not? We didn't think it was necessary. The CC and Articus were clear. You didn't think it was necessary to get legal advice before denying a disabled child's accessibility accommodation. Objection, Chambers said. Argumentative. Rebecca smiled thinly. I'll rephrase. Miss Kendall, are you familiar with the Fair Housing Act? Somewhat. Have you ever received training on Fair Housing Act compliance? No. Has the HOA ever provided training to board members about disability discrimination? No. So when you denied Mr. Grayson's application, you had no training in federal fair housing law, you didn't consult with an attorney, and you spent 7 minutes reviewing a request that would allow a disabled child to access her home. Is that accurate? Patricia's face was flushed now. We followed our procedures. Your procedures. Let me ask you this, Miss Kendall. The denial letter cited aesthetic standards as the reason for rejection. Can you explain what aesthetic standards a wheelchair ramp violates? It would be visible from the street. So would a staircase, which every house in the community has. What's the difference? Stairs are part of the original architecture. Ramps are additions that detract from the community's appearance. So a wheelchair ramp makes the neighborhood look bad. Is that your position? I didn't say that. But that's what aesthetic concerns means, isn't it? That you believe a wheelchair ramp would be visually unappealing. It's about maintaining property values and consistent architectural standards. Rebecca leaned forward. Miss Kendall, do you understand that your personal aesthetic preferences don't override federal disability rights laws? Chambers objected again, but the damage was done. Patricia spent the rest of the deposition defensive and flustered, and by the end, it was clear she'd never seriously considered that denying the ramp might be illegal. She'd simply decided it violated the HOA's rules, and in her mind, that was the end of the discussion. The settlement conference was scheduled for September 15th, just a week after Patricia's disastrous deposition. Judge Warren didn't attend settlement conferences himself. Instead, a magistrate judge named Linda Hernandez handled them. We met at the courthouse, with both sides in separate conference rooms. Judge Hernandez went back and forth between the rooms, trying to broker a deal. Rebecca was optimistic going in. After that deposition, they have to know they're going to lose, she said. This is their chance to settle before they are on the hook for a bigger judgment. Judge Hernandez came to our conference room first and introduced herself. She was a petite Hispanic woman with warm eyes and a gentle demeanor that probably helped facilitate settlements. I've reviewed your case, she told us. I think you have a very strong claim. Let me see if I can help the other side understand that. She went to the HOA's conference room and we waited. 20 minutes later, she came back, looking less optimistic than before. I've explained the strength of your case and the risks the HOA faces if this goes to trial, she said. They're willing to offer a compromise. They'll allow you to build the ramp if you agree to certain conditions. What conditions? Rebecca asked. The ramp must be painted to match the house. Landscaping must be added to partially screen it from the street, and you must agree to remove the ramp if your daughter no longer needs it in the future. I started to speak, but Rebecca held up her hand. Those first 2 conditions are reasonable. We can agree to those, but the third one is problematic. If Emma needs this ramp now, who's to say the next homeowner won't need it too? Or that the Graysons won't need it themselves as they age. Requiring removal is essentially saying your disability is temporary and inconvenient. I'll convey that, Judge Hernandez said and left again. Another 30 minutes passed. When she returned, she looked frustrated. They won't budge on the removal requirement, and honestly, they seem to think they're going to win this case. Their attorney is telling them they have a solid defense based on the CC and Articus. Rebecca shook her head. Their attorney is giving them terrible advice. I agree, but I can't force them to settle. Is there any number that would make you willing to drop the case? This isn't about money, I said immediately. My daughter needs that ramp. I'm not going to take a settlement that doesn't give her access to her home. Judge Hernandez nodded sympathetically. I understand. Let me make one more try. She came back 15 minutes later and shook her head. I'm sorry. They're not moving. This is going to trial. As we walked out of the courthouse, I felt both disappointed and angry. We'd given the HOA multiple chances to do the right thing, and they'd refused every time. Now we were going to have to go through a full trial, putting Emma through more stress and uncertainty. But Rebecca seemed energized. They just made a huge mistake, she said. When we win at trial, and we will, the judge is going to remember that they rejected a reasonable settlement. That's going to factor into the damages and whether he awards enhanced penalties. September and early October were consumed by trial preparation. Rebecca hired an expert witness, a former HUD official who would testify about Fair Housing Act requirements. We gathered Emma's medical records, photos of our house, architectural drawings of the proposed ramp, and documents showing the costs of alternative accessibility options. Rebecca took supplemental depositions and filed multiple motions. The HOA, meanwhile, seemed to be preparing for total war. They hired their own expert, an architect who planned to testify that the ramp would negatively impact property values. They subpoenaed Emma's doctors, trying to get testimony about whether her condition might improve. They even sent someone to photograph every house in the neighborhood, apparently trying to show that no other homes had ramps and that approving ours would open the floodgates. The trial was scheduled to begin on October 20th. The weekend before, I barely slept. Grace and I had explained to Emma what was happening, trying to strike a balance between being honest and not burdening her with too much adult stress. She understood that some people were trying to stop us from building her ramp, and she couldn't comprehend why anyone would do that. "Don't they know I need it?" she asked me the Saturday before trial. "They know, sweetie. They just care more about their rules than about doing the right thing." "That's mean. You're right, it is mean, but we're going to fix it." Monday morning arrived cold and clear. October in Phoenix meant temperatures finally dropping below 90, and there was something about the cooler air that felt appropriate for what we were about to do. Grace and I dressed carefully. Rebecca had advised us to look professional but not too formal. We wanted the jury to see us as regular people, not lawyers. Wait, there was no jury. Judge Warren was hearing the case himself, what's called a bench trial. Rebecca said that was actually better for us because judges were less likely to be swayed by emotion and more likely to focus on the law, which was squarely on our side. We met Rebecca at the courthouse at 8:30. She had 2 associates with her, both carrying boxes of documents and exhibits. Emma was with Grace's mother for the day. We decided she didn't need to sit through hours of legal testimony. The courtroom was more crowded than I expected. Several of our neighbors had shown up to support us. I also recognized a couple of reporters in the back row. The local news had been following the story, and apparently they thought the trial was newsworthy. Patricia Kendall sat at the defense table with Douglas Chambers and 2 other attorneys from his firm. She looked composed and confident, like she had no doubt the judge would rule in her favor. 2 other HOA board members sat behind her in the gallery. Judge Warren took the bench at 9. "Good morning. We're here for trial in Grayson versus Sunset Ridge Estates HOA. Are both sides ready to proceed?" Yes, Your Honor, Rebecca and Chambers said simultaneously. Very well. Miss Steinberg, you may give your opening statement. Rebecca stood and walked to the podium. She didn't use notes. Your Honor, this case is about a little girl named Emma Grayson who just wants to enter and exit her home independently. Emma has a neuromuscular disorder that requires her to use a wheelchair. Her family's home has 3 steps at the front entrance, which means Emma cannot come or go without someone physically carrying her. Her parents, Xavier and Grace Grayson, decided to do what any loving parents would do. They hired a contractor, got the necessary city permits, and planned to build a wheelchair ramp. That ramp would have cost about $8,000 and would have given Emma the independence every child deserves. She paused, letting that sink in. But the Sunset Ridge Estates HOA said no. They said the ramp didn't meet their aesthetic standards. They said it would be visible from the street. They said that Emma's disability was less important than the neighborhood's appearance. And when the Graysons tried to work with the HOA, tried to compromise, tried to find a solution, the HOA sued them, demanding they pay the HOA's attorney fees for having the audacity to ask for a reasonable accommodation. Rebecca's voice grew stronger. Your Honor, the Fair Housing Act exists precisely for situations like this. Federal law requires HOAs to make reasonable accommodations for disabled residents. A wheelchair ramp is not some extraordinary request. It's a basic accessibility feature that allows a disabled child to live in her own home. The HOA's refusal to approve this ramp is a clear violation of federal law, and we're asking this court to order them to approve it immediately, to award the Graysons their attorney fees, and to impose additional penalties to ensure this HOA never discriminates against a disabled resident again. She sat down, and Judge Warren nodded. Mr. Chambers stood, looking far less confident than Rebecca had. Your Honor, this case is not about discrimination. The Sunset Ridge Estates HOA does not discriminate against anyone. What this case is really about is whether HOAs have the right to enforce their covenants and architectural standards. Every community has rules, and those rules exist to protect property values and maintain a certain quality of life. When the Graysons moved to Sunset Ridge Estates, they agreed to abide by those rules. The CC and Articus clearly state that all exterior modifications require HOA approval. Mr. Grayson didn't seek that approval before filing for a city permit. He didn't follow the proper procedures. And when he finally did submit an application, the committee carefully reviewed it and determined that the proposed ramp didn't comply with the community's architectural standards. Chambers paced slowly. The HOA is sympathetic to the Grayson situation. No one wants to see a child struggle. But the HOA cannot make exceptions to its rules without creating chaos. If we approve this ramp, what's next? Oversized sheds, unpermitted additions, bright pink houses. The rules exist for a reason, and they must be applied equally to everyone. I wanted to stand up and shout that a wheelchair ramp wasn't equivalent to painting your house pink, but I kept my mouth shut. Judge Warren would see through this garbage. The HOA believes it has acted properly throughout this matter, Chambers continued. We followed our procedures, we carefully considered the application, and we made a decision based on our legitimate architectural standards. The Fair Housing Act does not eliminate an HOA's right to enforce reasonable rules. We ask that you dismiss the Graysons' claims and uphold the HOA's decision. He sat down and I watched Judge Warren's expression. He didn't look impressed. All right, the judge said. Miss Steinberg, call your first witness. The plaintiffs call Xavier Grayson. I stood and walked to the witness stand, my heart pounding. The clerk swore me in and I sat down, trying to look calm. Rebecca asked me to explain our situation, and I told the story from the beginning. Emma's diagnosis, watching her lose mobility, the decision to build a ramp, the HOA's interference. I described carrying Emma in and out of the house every day, how she'd started to resist going places because she knew it meant someone had to lift her, how that was destroying her sense of independence and self-confidence. "Mr. Grayson," Rebecca said, "did you consider alternatives to a front entrance ramp?" "Of course. I looked into every option. The garage isn't attached to the house, so that doesn't work. The back of our lot has a steep slope, which would require a ramp so long it wouldn't fit on our property. I even looked into stair lifts, but our entryway is too small. The front ramp is the only practical solution. And how much would that ramp cost? About $8,000. Have you already paid money in this case?" "We've paid Rebecca's retainer, court filing fees, expert witness fees, medical records costs. Probably close to $15,000 so far. Would you have preferred to spend that money building the ramp?" "Absolutely." Chambers cross-examined me, trying to make it seem like I'd deliberately avoided HOA approval or that I hadn't really explored alternatives. But his questions fell flat. There was no way to make me look like the bad guy when all I wanted was for my daughter to have access to her own home. Next, Rebecca called the contractor who designed the ramp. He testified that the design met all building codes and HOA standards, that it was the most cost-effective solution for our property, and that alternatives would be either impossible or prohibitively expensive. Then came the expert witness, Dr. Samuel Rodriguez, the former HUD official. He was in his 60s, distinguished-looking, and had spent 30 years enforcing fair housing laws. Rebecca asked him to explain the Fair Housing Act's accommodation requirements. The Act requires housing providers, including HOAs, to make reasonable accommodations in rules, policies, practices, or services when such accommodations are necessary to afford a person with a disability equal opportunity to use and enjoy a dwelling, he explained. The accommodation must be reasonable, meaning it's not an undue financial or administrative burden and doesn't fundamentally alter the nature of the housing. A wheelchair ramp clearly meets that standard. In your expert opinion, was the HOA required to approve the Graysons' ramp? Rebecca asked. Absolutely. This is one of the clearest Fair Housing Act cases I've seen. A wheelchair ramp for a disabled child is the textbook definition of a reasonable accommodation. The HOA's denial based on aesthetic concerns is not legally sufficient to override the federal accommodation requirement. What about the HOA's argument that approving this ramp would open the floodgates to other requests? Dr. Rodriguez shook his head. That's called the slippery slope argument, and it's specifically rejected in fair housing case law. Each accommodation request must be evaluated on its own merits. Approving a wheelchair ramp doesn't mean the HOA must approve everything. It just means they must comply with federal law. Chambers tried to challenge Dr. Rodriguez on cross-examination, but it was like watching someone argue that water isn't wet. The expert calmly cited case after case, regulation after regulation, all supporting our position. By the end of the first day, I felt good about our case. We'd presented clear, compelling evidence that Emma needed the ramp, and that federal law required the HOA to approve it. Day 2 was the HOA's turn to present their defense. Chambers called Patricia Kendall as his first witness. She took the stand wearing another expensive suit, her expression neutral. Chambers walked her through the HOA's procedures, the CC and ARTICS, the Architectural Review Committee's decision-making process. Patricia testified that the committee had carefully considered our application and determined it didn't meet the community's standards. Miss Kendall, Chambers asked, does the HOA discriminate against disabled residents? Absolutely not. We have several disabled residents in the community, and we've never had any problems with them. Why did the committee deny Mr. Grayson's application? The proposed ramp would be highly visible from the street, and it didn't match the architectural character of the neighborhood. Our CC and Articus specifically require that all homes maintain a cohesive aesthetic. We have to enforce those standards equally, or they become meaningless. On cross-examination, Rebecca went straight for the throat. Miss Kendall, you testified that you have several disabled residents in the community. Have any of them ever requested accessibility accommodations? Patricia hesitated. Not that I'm aware of. So you've never actually dealt with an accommodation request before this case? Not personally, no. And you received no training on Fair Housing Act compliance before denying Mr. Grayson's request? As I testified in my deposition, no. You consulted with no attorneys before making this decision. The CC and Articus were clear. We didn't think we needed legal advice. Rebecca pulled out a document. This is the meeting minutes from the Architectural Review Committee meeting where you denied Mr. Grayson's application. The entire meeting lasted 7 minutes. Is that correct? Yes. 7 minutes to decide whether a disabled child could have access to her home. We didn't need more time. The decision was straightforward based on the CC and Articus. Did you consider the Fair Housing Act during those 7 minutes? I'm sure it was discussed. Really? Rebecca showed her the minutes. Can you point to anywhere in these minutes where the Fair Housing Act is mentioned? Patricia scanned the document. It's not specifically mentioned, but we were aware of it. You were aware of a federal law that requires you to make reasonable accommodations for disabled residents. Yet you denied a wheelchair ramp for a disabled child in 7 minutes without consulting an attorney. Does that sound like careful consideration to you? We followed our procedures, Patricia said, her voice tight. Your procedures. Let's talk about those. How many accessibility accommodation requests has the HOA approved in your 6 years as president? I'm not sure. Isn't the answer 0? I don't have that information in front of me. Miss Kendall, I'm asking you to search your memory. In 6 years as HOA president, have you ever approved an accessibility accommodation? Patricia's face was red now. I don't recall approving any, no. And yet you claim the HOA doesn't discriminate against disabled residents. Objection, Chambers said weakly. Sustained, Judge Warren said, but his tone suggested he'd found the exchange illuminating. Rebecca moved on to Patricia's comments about aesthetic standards. She pulled up photographs of our neighborhood, showing them on a screen for the judge. Miss Kendall, is that a basketball hoop in the driveway of 2834 Desert Bloom Lane? Patricia looked at the photo. Yes. Is that permitted under the CC and Articus? Temporary recreational equipment is allowed. What about that flagpole at 2891 Desert Bloom Lane? Is that an exterior modification? Flagpoles are specifically permitted in the CC and Articus. And those solar panels at 2856 Desert Bloom Lane? Patricia shifted uncomfortably. Solar panels are also permitted. So the HOA allows basketball hoops, flagpoles, and solar panels, all of which are visible from the street, but not a wheelchair ramp for a disabled child. Can you explain that? Those items are specifically addressed in the CC and Articus. Wheelchair ramps are not. Because the people who drafted the CC and Articus never imagined the HOA would be cruel enough to deny one. Objection. Chambers stood up. That's argumentative and improper. Sustained. Miss Steinberg, please rephrase. Miss Kendall, isn't it true that the real reason you denied this ramp is because you don't want disabled people in your neighborhood? Patricia's eyes went wide. That's absolutely not true. I have nothing against disabled people. Then why won't you let Emma Grayson have a ramp? Because it doesn't comply with our architectural standards. Standards that apparently matter more to you than a child's civil rights. Objection. Withdrawn. No further questions. Patricia stepped down looking shaken. The next witness was Harold Winters, one of the other committee members who'd voted to deny our application. He was a retired accountant in his 70s, and his testimony was even worse than Patricia's. Under Rebecca's questioning, he admitted he didn't know what the Fair Housing Act was, had never heard of it before this lawsuit, and had simply voted to deny our application because Patricia told him it didn't meet HOA standards. The HOA's expert witness, an architect named Martin Fletcher, testified that wheelchair ramps negatively impacted curb appeal and could reduce property values by 1 to 2%. But on cross-examination, Rebecca got him to admit he had no actual data supporting that claim, had never studied property values in communities with accessible homes, and was essentially giving his personal opinion rather than expert analysis. By the end of day 2, the HOA's case had collapsed. Even Chambers seemed to know it. His closing argument the next morning was perfunctory, repeating the same points about HOA authority and equal application of rules. He couldn't explain away the fact that his client had denied a disabled child's reasonable accommodation without any consideration of federal law. Rebecca's closing was powerful. Your Honor, this case comes down to one simple question. Does federal disability rights law mean anything, or can HOAs ignore it whenever they feel like it? The Sunset Ridge Estates HOA chose to ignore the law. They chose their aesthetic preferences over Emma Grayson's civil rights. They chose property values, which their own expert couldn't prove would be affected, over a child's ability to enter her own home. And when confronted with their legal obligations, they doubled down, filing a counterclaim and dragging this family through an expensive, stressful trial. The HOA's conduct has been shameful from start to finish. We ask this court to order immediate approval of Emma's ramp, to award full attorney fees, and to impose additional sanctions to send a message that disability discrimination will not be tolerated. Judge Warren took the case under advisement, saying he'd issue a written ruling within 2 weeks. Those 2 weeks were agonizing. I knew we'd presented a strong case, but I also knew that judges could be unpredictable, and I couldn't shake the fear that something might go wrong. The ruling came down on November 4th, exactly 2 weeks after trial ended. Rebecca called me at work, and I could hear the smile in her voice before she said a word. We won. Everything. I sat down hard in my desk chair. Everything. Everything. Judge Warren issued a 32-page opinion, absolutely eviscerating the HOA. He found they violated the Fair Housing Act, ordered them to immediately approve your ramp with no conditions, awarded us full attorney fees which came to $68,000, and here's the best part, he sanctioned them an additional $50,000 for bringing the frivolous counterclaim. He said their conduct throughout this case showed a callous disregard for federal law and the rights of disabled residents. I felt tears welling up. Can I build the ramp now? You can start tomorrow if you want. The ruling takes effect immediately. I called Grace, then Emma's school, to let them know I'd be picking her up early. When Emma got in the car, I told her the news. We can build your ramp, sweetie. The judge said yes. Her face lit up in a way I hadn't seen in months. Really? When? Really soon? Maybe next week. That evening, Grace and I opened a bottle of wine and toasted to justice. Rebecca emailed us a copy of the judge's opinion, and I read it cover to cover. Judge Warren had been thorough and scathing. He reviewed the evidence, cited numerous Fair Housing Act cases, and systematically destroyed every argument the HOA had made. He specifically called out Patricia Kendall for her failure to even consider disability rights law before denying our application. The most satisfying paragraph came near the end. The HOA's position throughout this litigation has been indefensible. When presented with a request for a basic accessibility accommodation, the HOA's response was not to carefully consider federal law or seek legal advice, but to simply deny the request and threaten the Graysons with legal action. When sued, rather than acknowledge their mistake, the HOA doubled down and filed a retaliatory counterclaim. The court finds this conduct egregious and deserving of sanctions. HOAs are not above the law, and they cannot subordinate federal civil rights to their own aesthetic preferences. The Graysons should never have been forced to file this lawsuit, and the HOA must bear full responsibility for the consequences of its unlawful actions. The HOA had 10 days to appeal, but Chambers called Rebecca 3 days after the ruling and said his client wouldn't appeal. They were finally accepting defeat. I hired the contractor the same day. He said he could start work the following Monday and complete the ramp within a week. Emma counted down the days like it was Christmas. The construction went smoothly. The contractor and his crew were friendly and professional, and several neighbors stopped by to express their support and relief that we'd won. A few mentioned they were considering filing complaints against Patricia Kendall with the HOA membership. The ramp was finished on November 20th. It was beautiful, painted to match our house's exterior, with handrails and a gentle slope that met all accessibility standards. The contractor did a walk-through with us, then handed me his final invoice. "This one's already paid," he said with a smile. I charged it to the HOA's account like the judge ordered. That afternoon, I stood at the bottom of the ramp with Grace and Emma. Emma rolled her wheelchair up the ramp, slowly at first, then with growing confidence. When she reached the top and turned around, her smile was radiant. "I did it myself," she said. "You sure did, sweetie." She went up and down that ramp a dozen times that afternoon, reveling in her independence. For the first time since her diagnosis, she could come and go from her own home without help. That's all we'd ever wanted. The HOA paid Rebecca's attorney fees in December, though they tried to challenge the amount first. Judge Warren quickly denied their objection and warned them he'd impose additional sanctions if they continued to drag things out. The check arrived a week later. In January, I learned that Patricia Kendall had resigned as HOA president. According to neighborhood gossip, there'd been a contentious board meeting where several residents demanded her removal. She'd quit before they could vote her out. The new president was a woman named Jennifer Cole, who immediately sent us a letter apologizing for how we'd been treated and promising to implement Fair Housing Act training for all board members. The local news did a follow-up story, interviewing us in our front yard with Emma's ramp prominently visible behind us. The reporter asked Emma how it felt to use her ramp. "It feels like everyone else," she said simply. "I can go outside when I want. I don't have to wait for someone to carry me." The story aired that night, and my phone blew up again with supportive messages. Several people mentioned they'd had their own HOA problems and were inspired by our case to stand up for their rights. A week later, Rebecca called with interesting news. The Department of Housing and Urban Development contacted me. They want to open an investigation into the Sunset Ridge Estates HOA to ensure they are in compliance with federal fair housing law going forward. Is that normal? I asked. It can happen when an HOA loses a high-profile discrimination case. HUD wants to make sure they're not going to do this to another disabled resident. The HOA will probably have to enter into a consent decree requiring training, policy changes, and monitoring. Good, I said. Maybe this will actually change how they operate. In March, exactly 1 year after I'd first filed for a building permit, the HOA sent a formal letter acknowledging they'd completed required Fair Housing Act training for all board members and staff. They'd also revised their CC and RTCS to explicitly state that accessibility accommodations for disabled residents would be granted in accordance with federal law. Jennifer Cole called me personally to let me know about the changes and to thank us for forcing them to do better. I know this was hell for you and your family, she said, but you've made this community better. We should have been accessible all along. The case became something of a local landmark. Rebecca told me she'd been contacted by several other families facing similar HOA discrimination, and she was using our case as a template to help them. The judge's opinion was being cited in Fair Housing Act cases around the country. As for Emma, she thrived. The independence of being able to enter and exit our home on her own boosted her confidence in other areas. She became more social, more willing to try new things, more comfortable advocating for herself. The ramp was just a piece of wood and metal, but it represented something much bigger, the simple dignity of being able to live in your own home without barriers. On a warm April evening, I sat on our front porch watching Emma roll down her ramp to meet some friends who were walking by. She waved goodbye to me without looking back, just a kid heading out to play. Grace came out and sat beside me, taking my hand. Was it worth it? She asked. I watched Emma laughing with her friends, no different from any other child in the neighborhood. Every penny, every hour, every bit of stress. Absolutely worth it. The fight had been exhausting, expensive, and sometimes terrifying, but we'd won more than just a wheelchair ramp. We'd won Emma's right to live with dignity and independence. We'd established that HOAs couldn't ignore federal disability rights laws. We'd sent a message that families like ours wouldn't be pushed around by petty bureaucrats more concerned with appearances than people. The ramp stood there in our front yard, painted the same warm beige as our house, solid and permanent. Let anyone who saw it understand what it represented, not just accessibility, but justice, not just accommodation, but basic human decency. And not just Emma's victory, but a victory for every disabled person who'd ever been told their needs mattered less than someone else's aesthetic preferences. Looking back on everything that had happened, from that first threatening letter to the federal court ruling to Emma's first independent trip up her ramp, I felt an overwhelming sense of pride. Not just in the legal victory, though that was significant, but pride in standing up for what was right, in fighting for my daughter when a powerful institution tried to deny her basic rights, in refusing to back down even when it would have been easier to give up. The law was on our side, but the law doesn't enforce itself. It takes people willing to fight, to endure, to stand firm in the face of opposition. We did that, and in doing so, we'd made our community just a little bit better, a little bit more just, a little bit more aware that disabled people have the same rights as everyone else. Emma came rolling back up the ramp an hour later, still chattering excitedly about whatever her friends had been discussing. She wheeled past us into the house, calling back, "Thanks, Mom, thanks, Dad." As she disappeared inside, Grace squeezed my hand. She doesn't even think about it anymore. It's just part of her life now. That's exactly how it should be, I said. The sun was setting over the desert, painting the sky in shades of orange and purple. Our neighborhood looked peaceful, the kind of place where people raised families and built lives. And now, thanks to one federal judge who understood that disability rights mattered and one family that refused to give up, it was a place where everyone truly belonged, regardless of whether they walked through the front door or rolled. The Sunset Ridge Estates HOA had learned an expensive lesson. Federal civil rights laws aren't suggestions. Aesthetic concerns don't override human dignity. And when you discriminate against a disabled child, you're going to lose. That lesson cost them over $100,000 in attorney fees and sanctions, not to mention the humiliation of a scathing federal court opinion that would live on in legal databases forever. But for us, the lesson was different. We learned that justice, while difficult and expensive to obtain, was still possible. We learned that standing up for what's right, even when it's hard, was worth it. And we learned that our daughter was tougher and more resilient than we'd ever imagined. As darkness fell and the porch light clicked on automatically, I looked at the ramp one more time. Tomorrow Emma would use it to go to school, and the day after that to visit friends, and every day after that, for as long as we lived in this house. It would fade in the sun eventually, need repainting, maybe some repairs. But it would always be there, a testament to the fact that when pushed to choose between an HOA's petty rules and a child's civil rights, the law chose correctly. And that made every moment of the fight worthwhile.